Okay, very good evening and warm welcome to everyone that attend this class. Tonight, we are going to discuss November 2023 CPC paper. Okay, I'm going to do four questions today because I don't want to drag a lot of your time, and this will help you in your understanding better. Okay. And before that, I just wish to declare that I myself is merely a junior lawyer, in fact, very, very junior in this field. And I do not promise or guarantee you the outcome or quality of this thing. This is a pro bono basis. And I also cannot guarantee you the accuracy of the information provided here. And this is just a guide, but not your academical references. Anyhow, as you all know, LPQB had never officially endorsed any answers in our country. Okay, we also do not have adequate transparency to access to their standard or format of marking. Okay, I hope you do understand this first. Huh? Okay. The general approach to CPC question, which I would like to propose to fellow students would be, number one, you do not read the facts given first. You go to the question, okay, what the question required you to answer, then you go to the facts of this question. This will be very helpful to save your time. Secondly, you must understand the question. I repeat myself, you must understand the question. And then your answer shall be tally to that question. It is never an answer that regurgitated out of whatever script that you have memorized at home. It doesn't work, huh? Okay. And number three, your answer, if it is a CPC, your answer should be number one, follow whatever existing provisos that provided inside the CPC. Then you go to other relevant statute, for example, DDA, Child Act, or MACC Act, etc. Okay. Then lastly, you go to your case law. Do not jumble up. I know a lot of students will make a mistake to put case law first, but this is not how Malaysian legal system work. You should go to the CPC, then statute, then case law. This is the law here, the practice here. Okay. Number four, which is the most important part here is you must be absolutely confident and sure in regards to what question actually try to test you. That means to say, you are absolutely sure this is the answer for the question asked. There is no alternate explanation to that particular question. Like you are 50-50, not sure, and you have doubt. Then you try this question, I can assure you, you are not safe. I would say you are not safe. Okay. The most important part with this apa nama CLP is not to excel, Statistically, very few can pass with second lower class. You can check the past year records. Most of them will pass at the class. So that is to say, regardless how good you are from your undergraduate, some of you may be second upper class and also first class students. By this CLP examination, probably your grades will fall into class. So now you know a little bit of the rules, isn't it? Play safe, not play smart. Okay, very important, eh? Okay. So okay, without any further ado, we go to the first question. Okay, like I have told you earlier, you must go to the question first. Okay, read the question first. What are they trying to test? And then you go to the facts. This is how it works, huh? Okay. Question 1A, we are tested on one question that is to, let me just clear this out. Uh, okay. Okay, we are being tested uh, to determine whether the search on Bijan was lawful or not. So we have to read the factual circumstance very well. While conducting surveillance, a sergeant from the police force and his team saw Bijan looking suspicious. The police team approached Bijan and introduced themselves as police. Bijan kept mum, okay, did not respond anything lah, when he was questioned as to whether he kept any incriminating item. Bijan then tried to run away, but the police managed to stop him. After conducting a body search, you see, the keyword appears on Bijan, the police found a blue plastic package containing transparent plastic that contained clear solids suspected to be shabu, a drug. Okay. Bijan denied the package was with him before the police conducted the search on him. He was brought to the nearest police station and handed over to the investigating officer together with the item seized. As he was busy with other case, you see, IO took 5 days before the proceeding to record the statement of witnesses. Okay, so you are asked to, based on the scenario given, you are asked to answer question one by one. All right. So I will put forward my suggested answer as to question 1A. Okay, because they ask you to comment the legality, whether the search is lawful or not. So we will be discussing a few aspects. Okay, first and foremost, if you go to your this apa nama section 20A of your CPC, okay, look at the keywords here. This is how they check your answer. Okay, if you go to fourth schedule, it is at the back of your CPC actually. It provides the so-called how police officer should conduct a search on a particular person. Okay, so first step is the police had already done the introduction. That means to say, police had already reviewed their identity, maybe showing name card or showing their whatever, to suggest that they are acting as a police officer. And in fact, this turned out to be true lah, okay? So this is one of the general conduct under your section 3 fourth schedule in reference to your section 20A of CPC. Okay, very important. Okay. And then you must look at whether the search is being warranted or not. Why the police officer did not search other people but Bijan alone? Because the facts suggest that something fishy is going on. He looks suspicious. And secondly, this is all factual based. See, point one, look suspicious before the itu rondaan, surveillance was being done by the police. And then second, when he was asked about whether he kept anything or not, he kept quiet. Okay. And the third part is even more suspicious. He tried to run away. Okay. He tried to run away. So this is suspicions on part of Bijan. You must comment. Okay. And number 3 here. Okay. What law allow the police to do personal body search on Bijan? This one is always very important. Okay, you can see the facts here. Okay, I go back to the slides previously. Okay, you can see here, Bijan then tried to run away, but the police managed to stop him. Then only the body search been conducted, isn't so? This fact had given a hint to you or an inference to you that the search was made after an arrest without warrant. Okay, I hope everybody can agree with me at this stage. Huh? So the proper ruling here, I mean the proper proviso under CPC will be, you need to refer to, that is section 20 sub rule B of your CPC, where under this provision, the police is allowed to search the individual and secure all items found on them, of course, excluding their underwear and clothing, any items suspected to be to use in crime, or fruits and evidence, okay, of the crime can be held until the individual is either released or found not guilty. So the authority to do the search is actually from this, okay, section 20, sub-rule B of your CPC. You must be very clear with that. Huh? Okay. So this is additional information. If you do not have CPC with you, you can have a look at this slide, the same one that is being provided under your section 20A, the schedule behind of your CPC. Okay. Hmm. And then subsequently, you must be able to identify what type of search is it. We have several types of search, isn't it? Whether it's intrusive, strip search, etc. Okay, I will submit this is a type of down search lah, because they just go around the body and find one packet of drug. Okay, and authorization for this sort of search is not required. You have to comment on this. Otherwise, you see, why we want to rule that this search is lawful is that we want to prevent the Qs, I mean the OKS, OKT, the Bijan here, to charge police for trespass to person, for example, battery, or infringing their own privacy, molestation, if especially the gender is different. Okay, so authorization for this type of search is not required. So you can safely conclude that, okay, the police had performed the search according to section 20A. Okay, therefore, the search on Bijan is lawful. Okay, very important for you to put down the stand. What is your position? What is your final opinion in regards of the question asked? Okay, no question, isn't it? I mean, it's quite clear here. Okay, the second question is a general question. You are being tested about the objective of the search. I think this question quite easy, it come out as a compulsory question. It's a fair question. Okay. So where can you find the answer from CPC? Like I've told you many times, by now you should not regurgitate too much of case law, but try to look the answer from your CPC. Okay, the objective of search you can copy directly with little changes from fourth schedule of section 20A of CPC. Okay, the search conducted on a person okay, uh, carries following objective. Okay, number one is to find the incriminating evidence of the commission of the offense for which he has been arrested. Okay. Number two is to seize contraband. Contraband here means other barang seluduk. That means you are smuggling some drugs or illegal, those custom items lah. Okay, the proceed of crimes or any other things criminally possessed or used in conjunction with the offense for which he had been arrested. In this case, for Bijan will be the drugs, isn't so? Okay. Or C, for the discovery of evidence related to reason of the arrest or to preserve the evidence or prevent disposal of such evidence by the person arrested. Okay, so the objective of search have been well provided inside the CPC. Okay, and C, they ask you whether the arrest was lawful. So how do you go about that? How do you comment whether the arrest that had been affected on Bijan was actually a lawful arrest or an unlawful or illegal arrest? How do we determine? Okay, my proposal is as such lah. Okay, eh, okay. First and foremost, you must try to determine what types of offense probably committed by Bijan. I will suggest that he is committing some sort of section 12, section 12 lah, DDA 1952, which is punishable to the fine of 100,000 ringgit and imprisonment up to 5 years because he got a small plastic bag of shabu. Likelihood it is under section 12 sub rule 2. Unlikely to be section 39A lah, unlikely lah. Okay. So I will say, first I will tell that this type of uh, what we call offense is a seizable offense for possession of shabu. Okay, be very clear with your introduction because whether the arrest is lawful or not is depend on whatever your what we call whether the offense committed, Okay, so the said arrest in the question is arrest without question, without warrant, because the police did not get any warrant from magistrate court in order for them to catch Bijan, isn't it? It is a random one. It happens spontaneously. So your reference of your CPC shall be in accordance to section 23 sub rule 1 of CPC. Okay, do not elaborate too much, but be sure with the application which section of CPC that you should use in this particular scenario. Okay. So here, under this section 23 sub rule 1, it is provided that seizable offense, that's why I told you earlier on from this introduction, it's a seizable offense, isn't it? You see, this section 23 sub rule 1, seizable offense has been committed anywhere in Malaysia. See, any police officer may arrest without a warrant any person. Okay, this all is all contained inside your section 23 sub rule 1. Okay, and it should be read disjunctively. That means or atau salah satu kriteria telah pun dipenuhi, maknanya the arrest is lawful. As simple as that. So A, who has been concerned in any such offense or against whom a reasonable complaint has been made or against whom credible information had been received, or D, against whom a reasonable suspicion exists. So choose either one to fit in the scenario. Do not go and describe apa nama all the criteria. Oh, this is I received reasonable complaint lah. Oh, there's a credible information. You use a Shaban case and all that. You are not required to do so, So you have to tally the question to match the facts given. Okay, so reading from the above, what we call proviso disjunctively, I already told you, is apa nama? Is a or. In this context, Bijan falls into one of the criteria under section 23 sub-rule 1 CPC, whereby you have to fit in already. Okay, Bijan acts strangely when the police perform surveillance over the area. Furthermore, Bijan attempted to run away when he was interrogated by the police. So this is a reasonable suspicion. Okay, then you support your answer with case law. Then only your answer looks beautiful, you know. You get me? So Shaban against Chong Fuk Kam here had interpreted the meaning of reasonable suspicion will be depending each and every circumstances of the case. So that means to say there's no strict rule to define reasonable suspicion. But whereby Bijan here, something is wrong. Okay? So fit in 23 rule 1. Okay. Then subsequently, you have to know and also describe who is the person that made the arrest, because section 23 rule 1 provides for two types of person that can make the arrest. Number one is the police officer. Number two is the penghulu. So here, based on the circumstance here, the sergeant, isn't it? A team of police officer led by sergeant is a police officer. So where can you find the what we call the interpretation or the meaning or the definition of police officer? Then you have to cross check with your section 2 of Police Act 1967. Okay, so you can safely submit that sergeant is a police officer under the section. Okay, and then you have to comment what is the mode of arrest. But unfortunately, in these facts, you are not sure whether it is, touching the body, handcuffed, or being stopped, or being pointed with gun. You're not sure. Okay, so you have to roughly discuss section 15 sub-rule 1, at least to show that you know the statutory proviso for what we call the mode of arrest is under your section 15 sub-rule 1 CPC, and you have your common law provision is under Shaban, but you have to tell the examiner here it is not clearly mentioned in the facts. Okay, so this is how you comment. Okay, in lights of drug offenses, CPC is just a very general procedural code applicable for all the crimes committed in Malaysia. But whereas in particular crimes, for example, drug offense, you have to cross-refer to the specific act. That is your dangerous drug act, you know. Okay, so you have to slightly impress the examiners about the doctrine of generalia specialibus non-derogant, whereby if you look into your section 31 sub-rule 1 of your DDA, it provides that any police officer or any officer of customs may arrest without warrant any person whom he reasonably believed to have committed or to be committing an offense against this act. Okay, and every offense against this act shall be deemed to be seizable offense for the purpose of criminal procedure code. Okay, I hope this answer Mr. Sandeep's question. Okay, so any offense under drugs seizable. You must know the theories behind that, because Malaysian government had a very strict attitude from the past lah. 1952, since that time onwards. Okay, even that mandatory death for what we call death drug offense, section 39B. Okay, that's why all the drugs thing seizable offense. Okay, and again, it is obvious from the facts that strange behavior of Bijan had cast suspicion and belief. Sorry for the what we call grammatical errors, because all the question I have done just yesterday. So any errors you discover also, you let me know. Okay. He had committed the crime. Retrospectively, Bijan was found to have a transparent plastic suspected to have contained shabu. Therefore, the arrest by the police is lawful. Okay, you have to put factual analysis. Okay, because eventually you cannot just give a general statement, say that, oh, section 23 rule 1 CPC is well obeyed, and therefore police is apa nama, making a lawful arrest. Cannot do so. You will make yourself less analytical towards the question given. Okay, so I hope it clears some of your minds here. Okay, and question number D here, 1D, you are asked to explain whether there must be a promptness in recording the statement of witness. Okay, as you see here, okay, where's my pen? Okay, the pen is okay. You see, the IO took 5 days before the proceeding. Okay, the proceeding here probably, in my opinion, refer probably to the trial proceeding. Okay, it's not remand, it's trial proceeding. Record what? Statement of weaknesses. Okay, that's why every single words you must scrutinize and try to understand. It's not the accused witness statement, okay, but the statement of the weaknesses. So whether the IO should do it fast or not. So this is how the question tests you. Okay, okay. So first of all, you must understand what a kind of a statement is meant for. Why do we need to record statement? Statement is to be used, to be tendered to the court as evidence. Okay? So you have to check whether Evidence Act 1950 provides or not. There must be a contemporaneous or timely recording of the statement. Otherwise, the statement will not be admissible in court. Is there any? Okay, clearly, we do not have any specific provision under Evidence Act to say that you must record the statement, I mean, within 24 hours or within 1 week. Ada. Okay, so this one tak ada. Okay, then again, this is a drug offense. So you turn to Dangerous Drug Act 1952. Okay, did they say any what we call promptness of recording statement is necessary? Clearly, tak ada juga. But section 37, the presumption, the DDA presumption, the presumption of apa nama, possession, shift the burden to the accused. Okay, why I put this here is because I want to argue later on. Okay, because the burden shift to the Bijan that he did not have what we call the drug, okay? And CPC, does it provided under your CPC? Because if it is talking about the recording of statement, the first provision that you should refer to will be your 112 statement. Read together with 113. So you did not actually see they provide um, a clear-cut rules to state that you have to record the statement timely, They did not, tak ada, Okay. So in the scenario provided, okay, so how do you comment the 5 days, I mean, recording before the what we call the proceeding? Okay. So my argument in accordance to the scenario given will be, okay, the delay will cause the reliability and credibility of the evidence, as memories can fade, because witness may be also influenced, intimidated, or they have a discussion before recording of statement. So in this particular case here, you must think this is a so-called a surveillance, a ronda based on the police random surveillance over the area safety, isn't it? So the statements will be coming from the Sukan Peronda Police, the statement. So probably at the end of the day, if they discuss, and then the chemist test was also out, oh, they will put forward a well-drafted or schematized witness statement, So this could have negative implication to Bijan's case. If Bijan's counsel raised the issue of delay, it could potentially weaken the prosecution's case because it has a doubt, isn't it? The defense could argue the delay in recording the statement might have led to inconsistency or manipulation of evidence. Okay. Again, you have to conclude lah. Okay. So while specific statute that we have gone through, DDA, CPC, do not mandate the exact timeline, the principle, then you use your natural justice law. Okay, the principles of justice, fair trial demand the witness statement to be recorded promptly to ensure accuracy and also reliability of evidence. Delays such as 5 days, okay, prior to the proceeding in this case could weaken prosecution's case and also benefits to the defense. Okay, so this is my comment. Of course, you can have a different version. Okay, this is my comment towards the question tested. Okay, so second question. Okay, you are asked to distinguish a seizable and non-seizable offense. Quite straightforward question also. Okay, so what are their difference? Okay, number one, look at your CPC again, where you can find the seizable offense and non-seizable offense will be your section 2, the interpretation clause of your CPC. Okay, a seizable offense here refer to any offense, okay, whereby the police can arrest without warrant. Okay, very important, this is under your section 2 CPC. And also one thing here, you must refer to the first schedule. This one is first, first schedule, third column. Okay, usually seizable offense will carry imprisonment, okay, more than 3 years, whereby non-seizable offense will carry imprisonment less than 3 years. Okay, and usually seizable offense is bailable. Okay, sorry, seizable offense is not so bailable. It's not bailable. Okay, and non-seizable offense usually bailable. Okay, and in regards to remand proceeding, that means whether the police can detain the accused, the suspect, for more than 24 hours, seizable offense, yes, you can remand them, but usually non-seizable offense cannot remand. Okay, apart from this section 2 CPC, an offense, if it is less than 3 years, for example, here I'm saying to you, it is more than 3 years under third column of first schedule CPC, then it will be deemed seizable, isn't it? But if any other written law said that, like the DDA, said that any offense inside DDA is seizable offense, then the said offense will be automatically deemed to be a seizable offense. Okay, please get that in your mind. Okay, and B, in relation to first information report, you are asked to discuss, number one, whether the failure to adduce FIR at trial will trigger an adverse inference against the prosecution or not. Okay, first and foremost, you must try to understand what is an FIR. What is the FIR? So FIR here, our answer again should based on CPC. Okay, so you can find FIR under section 107 of CPC that outline the procedure to lodge a FIR. In a very layman term, FIR refer to police report. Okay, police report. It mandates that the report must be made to the police by the person given the information about the commission of an offense. So virtually everybody can make a police report, inclusive of police themselves, Okay. So secondly, you must look at why we have this sort of FIR. FIR is because police themselves will rely, they are not everywhere, isn't it? They will be relying the source of information provided by public in certain cases. So it lays a foundation, for the prosecution case. Because everything, there must be a trigger, isn't it? Tak boleh tiba-tiba sudah naik pergi mahkamah menghadap bicara, isn't it? So this is the earliest account from the alleged crime. Okay, then it can help to establish the facts and circumstances surrounding the offense. That means, for example, here I'm giving you theft that happened in my own house. So I go and report to the police saying that I lost 50,000 ringgit, a Rolex watch, and some golds. Okay, this is my police report. And then subsequently, I cannot modify, I cannot fabricate the FIR because this FIR thing I made on the day, and in fact, just maybe 1 hour after the theft was discovered. So there is some sort of accuracy and also contemporaneity of this particular evidence. What I say, I do not afterthought. I do not think and then, ayo, I should have declared to the police, I lost actually 500,000, and I lost a lot of jewelries, inclusive of one diamond ring, which cost about 300,000, so that I can use this police report to claim insurance. Take, for example, okay. So FIR itself, although this is not a substantive evidence, what it meant by substantive evidence means it proved the crime of a particular person, but it serves as a corroborative document. That is to say, it is a very good supportive document sokongan. Okay, it can be used to support the prosecution case and also cross-examine the witness, especially if there are discrepancies between their statement and FIR. This one is usually when we use because the trial will happen maybe 1 year after the incident, isn't it? Some of the material witness that had actually lodged a police report, suddenly they settle themselves. You know what I mean? They decided not to prosecute. They say something else. Oh, I did not see the witness. I did not see the accused that actually killed somebody. They got bribed by the family, for example. So we can use the FIR to impeach their credits, okay, something like that. Okay, first, you define what is FIR. Second, you go to the meaning. What does it mean by adverse inference? So adverse inference is provided under your section 114, okay, illustration G of your Evidence Act 1950, where the court may presume the existence of any fact which it thinks likely to have happened, considering the common course of natural events, human conduct, and public and private business. Okay, this what we call will draw an inference against a party who failed to produce that particular evidence. That means to say, the prosecution got this evidence, just because they got it, and some more this sort of evidence is very important, a material evidence that can influence the decision of the court at the end of the day, but they purposely withhold this and don't want to give to the court, then the court can pass this adverse inference, say that you have udang sebalik batu. That means you are having some hidden agenda. You want to win the case. You want to sabotage the accused. You are not doing justice. So this is what it meant by adverse inference under your Evidence Act, Section 114, what we call illustration G. Okay. And then you go to your case law. What does PP against Fong Chi Chung say? Okay. So you see, if FIR is reduced into writing, okay, before the investigation and not adduced what we call as evidence at trial, the court may make adverse inference against PP under Section 14, Illustration G of Evidence Act. Okay, this is first ruling. But if PP can establish a prima facie case against the accused without FIR. That means FIR has no bearing at all to the case. The police could have found the murder weapon, the other eyewitnesses, CCTV that support that an accused killed somebody. Tak ada FIR pun tak penting sebab it does not bring prejudice to the accused case, right? So in this sort of case, you don't need to give FIR and no adverse inference can be passed on you. Okay, so you look at the case of Tan Cheng Kui and also TP against Abdul Razak Johari. One more case also, Balachandran, a very famous drug case. The failure of the prosecution to produce FIR in court is not fatal, as the court will be of the view that the testimony of the witness, if believed, not being rebutted, is sufficient to establish any facts. So, again, so what is your position? What is your conclusion after citing all the laws and case law? So as a conclusion, the draw would only draw adverse inference against the failure of prosecution to produce FIR in evidence if the defense had attacked the credibility of the witness in relation to his testimony evidence which is not corroborated. Okay, like I've told you before, got discrepancy, and then the purpose of the withhold FIR is so important that can actually influence the decision of the court. Okay, if it is produced or tama, the prosecution can lose the case. That is the time where court can draw adverse inference. Okay. And the adverse inference, usually the court does not draw it automatically, We, I mean, the lawyers, private lawyers, the defense counsel have to submit, We have to plead it. We have to name this as our defense, Okay, so this is how the practical things work, lah. And B2, whether the accused is entitled to a copy of FIR. Okay. Historically, because this 8-mark question is historically, the straightforward answer is it is not an automatical right for the accused to get the first information report, as you can see from case of this Anthony Gomez, who's D, okay, Lu Fangxiang, and also Balachandran. Okay, so historically, no, FIR, it is not the prosecution, the DPP will not just give you as of right. You have to request. I mean, not you, the accused has to request by writing to DPP saying that I need the FIR to prepare my defense whatsoever. But these are all historical approach. You must be clear with the position of law. But ever since the introduction of Section 51A of CPC, okay, Section 51A of CPC is the new amendment of law whereby the prosecution, okay, must supply the accused with the copy of information, documents, material evidence that they want to use. Okay, the keyword here, see, they want to use during the trial. Okay, so this is inclusive of the FIR here. Okay, so this is the modern approach. So this is also one of the case that cited here is Balachandran against BP. Okay, so nowadays there is no much argument as to the entitlement of accused towards FIR because this is an automatical right. The PP, DPP will surely give you the police report. 100%. Confirm, Okay. So Section 51A CPC has shifted towards greater transparency lah. Because at the end of the day, the bargaining power between the accused and also the prosecution are so different. The accused sometimes very poor, uneducated. They are being, they don't even have money to hire lawyers. So if you still hide things from them, how are they supposed to get a Twitter or even a fair trial, isn't it? So nowadays, you have to summary in such lah. Okay, earlier cases, historically, the what we call the grant to access to FIR will be subjected to the discretion of the court. But after the introduction of this new Section 51 ACPC, okay, the accused have automatical right to get FIR. And in fact, other documents also, inclusive of the photos of the crime scene, etc., the chemist report, etc. Okay, this is to ensure a fair trial and justice. Okay. Okay. C. Explain the procedure to investigate a seizable offense. Okay, this one is quite easy lah. Okay, you can look for the answer from your section 109 to 120. Okay, so briefly tell the examiners what you want to tell. Okay, the procedure to investigate on seizable offense is outlined from section 109 to 120 CPC. Okay, in brief, do not just copy everything because this is just a 5 marks question. So section 109, okay, after you get the information about seizable offense, for example, a murder had taken place, a sergeant or above, this one keyword, it cannot be, lance corporal or corporal, something like that. Okay, the one that with a tiga palang, okay, should conduct investigation without unnecessary delay. Okay, and section 111, okay, again, sergeant and above, okay, it could be sergeant, sergeant major or inspector must report to PP, and then he himself or his deputies must go to the crime scene. Okay, he must come lah. A serious crime here, had been committed. So you must take a ride to the place where the offense taken place. Kan tak datang, betul tak? So kena pergi. So section 111, okay, said that the police can summon the person that know about the case, okay, to come. Panggil orang datang. It could be the accused or the what we call the witness to come to help them in their case. Okay. And then section 112, you read together with your section 113. That is to record statement. Okay. Ambil itu apa? Pernyataan saksi. Okay. statement from the witness and also suspect. Okay. And then section 116 provide that the police can conduct the search. Okay. The search over the place. Lah. Okay. And then you have section 16A, that is to access towards a computer. Lah. Especially you have some sort of jenayah, sexual kana, you have put in a lot of pornography inside your phones, you know. This section 116A will allow the access of police. And then section 17 is your remand. Lah. You have to read together with your section 19 because seizable offense, as I told you earlier, usually is a form of serious offense. You are scared that you cannot finish the investigation within 24 hours. Then you are also scared that the suspect may run away. So you will need to go to the magistrate if you cannot complete, I mean, the police cannot complete investigation within 24 hours to ask for remand. Okay, depends how long the remand orders based on the length of the imprisonment of that particular offense. Okay, after that, after you finish the investigation, all that, you will have to write um investigation report, okay? You have to give a IP paper, okay? That is investigation paper lah, IP to the prosecution. The prosecution will decide whether to go ahead with the charge to the accused or not. So this is roughly the brief summary of the procedure on how the investigation of apa nama, seizable offense take place. Okay, if let's say the investigation to the point you collect all the evidence from the witness statement, you search the what we call the crime scene, you found nothing. At the end, TP is the one that decide not to charge the police, the accused, okay. So get yourself familiarized with that lah. So far so good, okay. Or are you still with me? Okay. Okay, very good. Okay, we proceed with our third question. Distinguish between lateral transfer and vertical transfer of a criminal case. This one also very straightforward and very low marks given. So lateral transfer refers to any transfer of the courts of the same level, or what we call as coordinate jurisdiction. That means magistrate to magistrate, session court to session court, or one high court from MOA to JB, something like that. So this is same level transfer. This is called lateral transfer, whereby vertical transfer refers to transfer from subordinate courts, lower courts to superior courts. Usually session court to high court or magistrate court to high court, for example. Okay. And the governing provision here, lateral transfer is section 417 and 418, and whereby vertical transfer is governed by section 177, 417. 417 is not a standalone. You have to read together with the 418 together because 418 is how you apply. Okay. And 418A CPC, that is the personal power of public prosecutor, okay, to transfer the case to high court. Okay, usually high profile case. Okay, so reason to facilitate convenience, administrative reason. Okay. Mm. So lateral transfer, vertical transfer, very easy. Okay. The harder part is actually question B1 and B2. Okay. B1 here, you are asked to advise, apa nama? You are asked to advise the DPP whether session court judge can transfer the PJ cases to KL Session Court, and whether KL Session Court has jurisdiction to hear PJ's cases. Okay, so this is your question. We go back to the facts. What happened? So Pute was charged in Kuala Lumpur Session Court with two offences under Section 420 of Penal Code. Okay, KL cases lah. He was also charged in Petaling Jaya Session Court, PJSC, with two offences under Para 4 Subrule 1, Subrule A of AMLA. Okay, PJ cases. So before PJ Session Court, the learned deputy public prosecutor applied for the transfer of PJ case to KLSC on the grounds inter alia. One, the charges for the PJ cases originated from KL case, where the money recovered from the PJ cases had become the subject matter, okay, in the KL cases. So there are connection, okay, between the Section 420 and also AMLA. It's actually the same money, okay? And number two, there was a connection between KL cases and PJ case, and the transfer was necessary for the purpose of joint trial of all the charges. And three, the offences were committed within the Klang Valley area, and therefore the accused interest will not be prejudiced if the case were heard in KLSC. And fourth, the charges involve the same witnesses and reference to the same documents, and such would save time and cost for all parties. So the learned session court judge dismissed the learned DPP's application on the ground that he could only transfer PJ cases to KL session court if later has jurisdiction over PJ cases. Okay, you see, PJ cases. So DPP subsequently made an application to the High Court in Malaya and Shah Alam for revision, okay, revision of the decision by the learned session court judge. Okay, if you have a choice, not to answer this question, I will seriously recommend you so, because I have discussed with one of the tutor here, his answer is a little bit different from mine. So, like I've told you before, if you have alternate answer in your mind that provide answer for this sort of question, it is good time for you to make absolute shun and void approach, not to answer this question in entirety. Okay, I make myself clear. This sort of question, very tricky, and you do not know what area of law that they are trying to test you. So I can only try my best based on my personal understanding of this question. Okay, I will advise DPP. Okay, and someone you have to not to discuss, not to discuss the local limit of jurisdiction, okay, assigned to PJ Session Court and also KL Session Court. Okay, you cannot discuss, so B1, okay, they are two limbs of the question that are being tested. So based on the facts provided and also relevant provision of CPC and also what we call related law, we need to address two key issues. Okay, first, whether SCJ can transfer TJ cases to KL Session Court. Okay, and second, whether KL Session Court has jurisdiction to hear the cases or not. So my suggested answer is like this. So whether this Session Court judge has power to transfer the case or not, I will submit the authority, the power that given to SCJ to transfer case is not inside your CPC, okay? But rather, you have to cross-refer to your Subordinate Courts Act 1948, okay? This is two references, two proviso, which is your Section 99A, okay? Inside this Subordinate Courts Act itself, there is a third schedule at the back of your SCA, Okay. Inside this third schedule, Section 3 Subrule 2 grants the session court judge power on application, that means on the application, whether by the accused or DPP or on its own motion, to transfer any proceeding to another court of coordinate jurisdiction. Because here is PJSC to apa nama? KLSC, isn't it? So it is coordinate jurisdiction. And in furtherance, Section 104 SCA provides that SCJ or magistrate has authority to order the transfer of any criminal cause or matter to another session court or magistrate court if interest of justice so required. So the transfer can be ordered regardless of whether SCJ or magistrate has final jurisdiction to hear and determine the matter. So famous case here, Mano Current against BP. Okay, so you get the power from here. Not you, SCJ get the power from here. Okay, so this is, I make things easier for you to revise. This is the third schedule, section 3, SCA. Okay, and in line with your section 99A of your SCA. So this is the one. Okay, section 99A. Okay, and on top of that, you have your section 104 of your SCA. Okay, very important. So these are where the power of SCJ vested in whenever they want to make a transfer of proceeding. Okay, so on application of PP, SCJ can actually transfer. So based on the my answer lah, section 99A and also 104. Okay. And second limb of the what we call the question would be, you are asked to dismiss the requirement of local limit jurisdiction provided under section 121 to 127 of CPC. The jurisdiction of KLSC to hear this matter shall be discussed within the ambits of sentencing and trial jurisdiction of the said court. Okay, so this is my personal understanding about this question, you know. Okay, so you must know what is the offense about. Okay, the offense here is section 4 AMLA, isn't it? Okay, so section 4 AMLAs, okay, this is in full lah. In fact, you need to know only this. Okay, imprisonment, okay, not less than 5 times of the sum, okay, and also imprisonment not exceeding 15 years or both. So you are to determine whether session court has trial jurisdiction and sentencing jurisdiction or not. So my suggested answer is for you to look at section 63 of SCA. Okay, like I say, if you have a choice, try to avoid this question because you are not being supplied with SCA during examination. So any wrongful, or what we call you have mistakenly applied the section will lead to fatality of your answer. Okay, so SC can try any offense except those punishable of death punishment. So this is case law Nadaraja. Okay, so sentencing jurisdiction here under section 64 SCA. That means to say they can pass any sentence allowed by the law except death penalty. Okay, so Bachit against what we call PP. So you conclude at the end of the day, you say that KLSC has both sentencing and trial jurisdiction to hear the case. Okay, so this is my personal answer. Okay, and then subsequently, the next question, you are being asked to examine whether the requirements for the transfer of PJ's case to KLSC have been met. Okay, actually, to be honest, these two are the very tricky question. Okay, those are the type that you should avoid lah. And because when you ask some other people, they may understand the question in a very different way, you know. Okay, so I personally, from my understanding, okay, the question asks you on the requirements for the lateral transfer, isn't it? I will discuss based on the factual merits and also procedural grounds because why I want to discuss factual merits is because the question give you so many grounds here, you know, all based on the facts of the case, you know. Okay, you see, okay, my suggested answer is as such. Okay, grounds for transfer provided by DPP. Number one is they say that these two cases are connected. They want to have joint trial. Subject matter AMLA dengan itu section 420 lebih kurang sama. So this is connection. Okay. Number two, judicial efficiency. Because they said if the case just do it in KL, the witness may just come one time and then documents will be the same, and then it will save time, resources, and also cost. Okay. And number three, they submitted that there is no prejudice to the accused because offense occur in Klang Valley. So transfer itself will not jeopardize the accused in terms of the geographical proximity. So the merits of his case supported the transfer to save time. Okay. So in reliance to, because they already made an this application in high court, isn't it? So in this what we call in this question, I will put forward section 417 in reliance to section A, D, or E. Okay, so the merits of this case are as provided in the facts of this question falls into the criteria of your section 1417 subrule 1A, D, or E. Okay, you can have a look of your section 417. Okay, so whereby, okay, actually High Court can, I think I copied the wrong one. By right, it should be section 417. Give me a minute. Okay, here. Okay. See, 417 when application made to High Court, okay, if it is the High Court, it when it appears to the High Court that a fair and impartial trial cannot be trial in any criminal court subordinate to it, then it can transfer. Okay, or C, uh, sorry, D. Okay, then that an order under this section will tend to the general convenience. Okay, that means save cost and also witness. And E, expedient for the end of the justice. So it fits in the criteria to make the transfer under this list. Okay. So what is the decision by what we call SCJ? SCJ said that he dismissed the application based on the judicial appreciation that KL Session Court must have jurisdiction over the PJ cases for the transfer to occur. Okay, and your answer, my answer lah, okay, I will put forward that actually High Court in Malaya and Shah Alam has the power under your section 417 subrule 1 BB to transfer if it deems that a transfer served at the end of the justice. Okay? So this is my version of answer, you know, because local limits jurisdiction, you do not have to discuss. So you go to the grounds of transfer. Why the case merits itself? Why, how does it benefits from the transfer to happen? Okay, so my first limb of the argument because entirely this is my personal opinion. Okay, so second, whether DPP FAR revision under section 323 to 327 to High Court is appropriate or not? Is it the right procedure to make transfer once SCJ dismiss his application? Okay, so I will say that it is tried law that if the decision of subordinate court can be appealed, but it's not appealed, then the revisionary power of High Court should not be resorted to. Because revisionary power here is referring to supervisory power of High Court, okay, semakan. So unless the said order you cannot have any other alternative measurement, and this is exceptional cases already, then you should apply for revisionary power. Okay, then you apply for revision under High Court. So clearly, I think this is not a good idea for DPP to apply for revision. Okay. So procedurally, DPP should make an application by motion lah. Okay. My personal answer is as such. You have to follow the procedural requirement provided under section 418 subrule 1 CPC. Okay. And such application shall be made before the inquiry into a trial or a trial of the offense had been concluded. So this is section 418 subrule 2 CPC. So in advising DPP, it is submitted that the case merit, the factual merits, okay, for the transfer had been met. Okay. So my first limb. However, the application method by way of revision might expose DPP to objection and subsequent challenge by the opposing counsel, as the right procedural rule should be section 418, okay, CPC. Okay. I not talk about charge necessary. Some people will talk about the charge lah. Provide SC can hear and determine. Okay. The C Miss Bay, is it? Okay. Bay Xin Yan had asked, do I need to talk about the charges necessitate a transfer of case for the purpose of joint trial? Then go and discuss territorial jurisdiction of session court under section 59 subrule 2 and also PP against Segaran, isn't it? You are not required to discuss local limit of jurisdiction as clearly provided inside the question. Therefore, you do not need to discuss all that territorial allocation under your section 121 to 127, as well as the local jurisdiction provided inside your SCA. Not required, okay? And this is one typical example of USO lah. Okay, USO, even though you do PP, I mean, if they make application under section 418, they do not need to have affidavit, but they still need to give alasan. What is your grounds? Okay, the grounds usually is factual. What is the facts that you want to say? What is your support? Okay, to make that transfer happen. Okay. And question 4A. Okay, you are asked to critically examine the council's submission that section 51A of CPC is a mandatory provision. Okay, section 51A, please study by heart lah. I've seen this question repeatedly come out. It's part of the favorite question of CPC. So we'll read the question. So the accused was charged under para 17B of Malaysian Anti-Corruption Commission Act, corruption, I mean 2009. The charge concerned the accused bribing a police officer at the police station in Lubuk, China, Malacca, whose bribe was in the sum of 3,000 ringgit. The accused had been arrested by the police on suspicion of stealing buffaloes. At the police station, the accused was alleged to have bribed the IO, and such bribery was witnessed by another police officer. At the end of the trial, the learned session court judge found that the accused story that he was framed by the IO and the police officer not to be credible, and found that the prosecution had proved his case beyond reasonable doubt. The accused was accordingly convicted against, which conviction the accused now appeals. Okay, one of the ground raised in the appeals by the defense, okay, is that the prosecution had failed to comply the requirement of section 51A of CPC by not serving the accused what are the documents not served? Charge sheet, arrest report, and statement of accused. So counsel for the accused contends that section 51A of CPC is mandatory, compulsory lah, okay, provision, and accordingly submits that the conviction and trial should be set aside because defense tidak dibekalkan dengan dokumen-dokumen seperti kertas pertuduhan, uh, report penangkapan, and also his own statement. So whether this is valid or not, we will answer lah. Okay, we will need to answer. Okay, based on the facts, don't just regurgitate the law. I already said many, many times. Okay, so section 51A, what is that? Okay, just briefly outline. Okay, section 51A CPC mandates prosecution before trial, okay, to deliver the accused the following documents. Just now, I think we discussed already the FIR, okay, and also any copy of documents that will be tendered as part of the evidence for prosecution, okay? Remember what I say, and a written statements of facts favorable to the defense of the accused signed under the hand of public prosecutor or any person conducting the prosecution. Okay, see, so the core issue here is whether to failure to comply with section 51A of CPC is fatal or not, because the ground of appeals means SCJ sudah terkilaf dari segi undang-undang. That means SCJ here made a mistake, okay, by allowing the what we call the accused not being supplied with the arrest report, charge sheet, as well as the statement of accused. Okay, then subsequently convict the accused, whether it is right or not. Okay, you have to understand. So whether this is a mandatory or just a directory is very important. Whether this is compulsory, jurisdictional matter, or it is just a technical error that does not actually reshape or nullify the trial. So you have to argue. Okay. So how you argue? First of all, you go to the literal interpretation. Okay, how do we construct this section 51A? Section 51A here actually got the word shall, shall by any literal approach under Malaysian court law as well as common law approach, it indicates a mandatory requirement. Mesti, wajib, kena buat. Okay? Mandatory requirement. So, court have usually interpreted shall as imperative, suggesting that the prosecution must comply with provision. Okay, because at the end of the day, section 51A, I think I told you earlier, is to ensure the accused had equal footing or equal bargaining power, because prosecution got every resource. Whole police will support prosecution. They have so much access intels here and there. You see, accused stand alone with his lawyer lah. Probably that was be the best outcome. Okay, if the lawyer do their work, it's lucky for the accused. If not, he's left alone one, So 51A is to ensure fair trial. This is provided under this Datuk Sri Anwar Ibrahim case. Okay, to ensure equal footing or bargaining power between prosecution and the accused. Okay, so the case law that support whereby Section 51A is mandatory in nature will be PP against Karpal Singh, whereby the court said that it is mandatory. Okay, you must follow. PP must follow. So similarly, Lee Lu Chuang here also said that prosecution must supply the necessary documents as required by Section 51A. Okay, but you are asked again, I put big here, you're asked to critically, you see or not? Critical means you have pro and con. You have supportive and also you have rebuttal argument. That is normal adversarial system, isn't it? So there are also some case law saying that Section 51A is directory in nature. It is just nickel. Not necessarily you must follow it. Okay, so this is provided in two cases. Benjamin Benjamin William Hawkers against PP, as well as PP against Muhammad Fazil Awaluddin. Okay, non-compliance with Section 51A does not make this trial a nullity. So this section was actually, anyhow, if you look at the whole CPC in as a whole in a context, so criminal procedural code, you know. So this is just a direction, it's just a guiding, I mean guiding rules for you to follow in criminal trials, It is not substantive law, It is not like your DDA, it's not like your MACCA, all that. It's not. But it is just a guiding how the trial being conducted, how the search being done, how remand procedure should be conducted, etc. Isn't it? So why you say this is substantive law? So these are the arguments put by the smart counsel inside these two cases. Okay. Now we have to come back. Okay. So therefore, you have to submit one thing. Since you have a pros and cons argument, you still have to play around. So while non-compliance with Section 51A, okay, is a serious matter and could impact the fairness of the trial, it does not necessarily mean that the setting aside of conviction. So the court retains discretion to determine the impact of such non-compliance, considering whether it was deliberate and in bad faith or not. Okay, whether it prejudiced the accused right to a fair trial. Eventually, when you are to discuss critically, you must understand the rationale behind Section 51A. Kenapa Parlimen mau menguatkuasakan Section 51A? Kenapa? Apa sebabnya? So, this is critical Okay. Then, not finished yet, So you have to you have to tally your arguments based on the factual circumstances given in this question. Okay, I will put forward my stand, and you can only choose one. You cannot hang between. Okay, so in the given case, the accused argue that prosecution's failure to comply Section 51A by not serving hardship arrest report statement warrants the setting aside of the accused because the learned defense counsel already put in their appeals submission. Okay, but consider each and the importance of every single documents highlight here. You see, the charge sheet, is it important? The charge itself usually read to the accused, in the language that he or she understood before the commencement of the trial. Usually, this is the first thing to happen, isn't it? Okay? The pertuduhan akan dibaca. pada orang kena tuduh ataupun orang kena saman. Like that. This is confirm will happen. So the court shall ensure the accused understood what kind of offense they committed, how they committed the offense, and what are the punishment followed by that. Okay, this is my first point. And some more second point is the arrest report. Arrest report is private and confidential one. It is only the police had access towards arrest report because a lot of intel information, especially drug syndicates, gambling, groups, for example, how they arrest. There will be some people, they are informers, or agent provocata, provide information. So arrest report will not be revealed to accused. Kang Ho Su here. And third one, statement of accused. That one is actually section 112 CPC, which is subject to the privilege of your section 113 CPC, whereby the accused statement could only use in favor of accused, Okay. So in this context, because I have to choose one, isn't it? I cannot hang between. Okay. I will submit that there is no prejudice, okay, and there is no requirement under Section 51A to provide such documents to the accused. So therefore, it is unlikely that the appeal of the accused will be allowed by Court of Appeal. Of course, you can submit different way, but only important point is why you say so. You think because charge sheet not given, arrest report not given, statement not given, so your preparation of your defense is insufficient, inadequate, and then causing the what we call the prosecution to prove beyond reasonable doubt also can, so long you have a good reason. My position is no lah, because I think these documents is not so important. It's not so important. Okay, personal view, okay, you can have a different submission so long you don't hang in between. Put your stand firm and clear. Okay. Time is it now? Okay. Okay, almost done. Okay. Section 51 CPC is a general provision to be invoked at any stage of inquiry, investigation, or trial, or other proceeding under the code. Explain the statement above. Again, this is like, but this one lucky lah. You just memorize a script and then you can regurgitate because it has no much connection to the facts required. Okay, so section 51 CPC, in basic understanding, to make your life easier, it is just like a discovery procedure in your civil proceeding. Almost the same, okay? It's a disclosure power that the court can give to summon, examine witness, production of documents or any items. Number one, two keywords here. Okay, the pen. Okay, provided those items is necessary and provided the documents or the evidence is relevant to the charge. Two things only. I repeat, Section 51 CPC is a disclosure power, just like your discovery procedure inside your rules of court. Okay. So long the production of that particular evidence is necessary and relevant to the charge involved. Okay. Towards any person can, okay, the court can make it compulsory, okay, for the production of documents and things. Take, for example, there's a case of forgery here. Only the accused has the original copy of the forged copy, but he refused to give. Without the original copy, you cannot send the photostat documents to chemist department to test for forgery, isn't it? So you can go under section 51 CPC to compel the accused to tender the original documents for the examination. Okay. So this is a general provision because it could be invoked at any stage of criminal process, namely your inquiry stage, whereby the facts are being gathered. Anytime can. Okay. Investigation, where the police are collecting officer evidence and building their case. Okay. Because without the material evidence, you cannot charge, isn't it? So how do you compel the other party to give? So this is by section 51. So even during trial and also other proceedings, that means during appeals also you can, post conviction and other judicial process also can. Okay, so this one is very broad, broad application, broad disclosure power of the court. Mm. So I already told you, Section 51 empowers court and police officers to compel summon of evidence. Okay, summon person to produce documents or items. Consider, you must highlight necessary and also relevant. Okay, and you can use the case of PP against Teo Chun Tek here. Okay, whereby the judge said that it is not question at the stage of whether documents is admissible or not. It may be the thing called for may turn out to be wholly irrelevant to the inquiry, but so long it is considered to be, you see or not, two elements necessary, okay, for the purpose of the inquiry, the power is there. So relevancy plus uh, necessity. One of it is fulfilled, then section 51 can go through. Okay, very important, eh? So in Haji Abdul Ghani Ishaq, the court adopted the principle in Teo Chun Tek case pertaining to the necessity or relevance of the documents. Okay. Okay, the rights to have access to documents or things under section 51 is much dependent on the stage of proceeding at which an application is made. If the application is made before the commencement of trial, the application must specify. Okay, you must make a disclosure. It's just like discovery. You must seek for what kind of documents lah. You cannot seek for semua dokumen yang dipegang ataupun dimiliki ataupun di bawah control or custody of the what we call the accused or other witness must be put forward. How am I supposed to know which documents to give to you? So you have to specify. Okay. And in Kulwan against PP, the court also added that if the stage of the proceeding is during a trial, the documents asked for must be relevant to the issue for adjudication. Okay. One other important point is that Section 51 CPC is not only applicable to the accused person, but also to the prosecution to obtain witness from opposite side by way of discovery. Okay, even witness also can, see or not, they can compel any individual to, in order for them to get the evidence, thing, documents, or any other evidence. Okay, so this is disclosure provision. Okay, and this is roughly the repetition. So the provisions general nature allow for its use during inquiries, investigation, trials, and other proceedings, ensuring the justice is served through the availability of all pertinent evidence. Okay, the rationale behind section 51 is disclosure. Okay, that means to say all the things must be put forward before the court. So the court can have a full evaluation and also assessment in order to find out what is the truth behind the case, then can give a justice. Okay, so this is the provision under section 51. You are not required to discuss section 51 and 51A are separate. You don't have to discuss Datuk Sri Anwar Ibrahim, Nana Raisa case, all that you don't have to discuss. You just have to discuss what is the purpose of section 51 uh, and how is it can be used. Okay. Last question is, I think, explain whether the accused is entitled to a chemist report, 3 marks. Okay, so chemist report fall under which apa nama section of CPC? Okay, I will use two sections to support this answer. Very short and sweet one. First, I'll use section 399 CPC, whereby the PP, if the intents, okay, first I define what is chemist report first. Okay, it typically contain those forensic analysis, usually drug case, okay, drug case from Jabatan Kimia, okay, that can be crucial evidence in criminal trials. So this is under your section 399. If let's say the PP is not intended to call the chemist, the ahli kimia, the pegawai science to give evidence in the court, they should give this chemist report to the accused not less than 10 days before the commencement of the trial. Okay, but you do not need to elaborate more. And some more, Section 51 A, Subrule 1, Subrule B, mandates prosecution to furnish the accused with certain documents before commencement of the trial. This one, I think we have make it, isn't it? Chemist report usually will be used by PP to establish the elements of crimes of the accused. Therefore, Section 51A required PP to give the accused. So you conclude that the accused is entitled to chemist report. Okay? Full stop. As simple as that. Okay. So far, I think that will be all about the discussion today. I hope it's not too burdensome for you. 1.5 hours already lapsed.